anticipatory bail application filed by Subhash Velingkar. We have applicants advocate Pranav Pathak. Sir, there is a bit confusion. One side is saying that petition has been simply disposed of. There is no matter of granting anticipatory bail because he has complied with the 35 notice under BNSS, and there was no issue of arrest, so there is no issue of granting anticipatory bail. What is the clarity? What is your view?
My view is the anticipatory bail has been granted since we applied for it, and we have complied with the conditions which were stipulated in the earlier order. So, since the nature of it pertains to law and not politics, on the subject matter of law, we are very clear that the anticipatory bail has been granted and the application stands disposed of. Otherwise, it would have been rendered in the court till the time it is further decided in the future. And the sum and substance remains to be seen whether in the future what is uploaded in the order sheet later on by the Honorable High Court. Since we have complied with it, the bail has been granted and there is no apprehension of arrest. The apprehension of arrest has already been mentioned in the oral order which was dictated today. So that is the nature and sum and substance of it, that the bail has been granted to the applicant and not vice versa.
So when the argument commenced, what was the submission of Bicholi police?
The Bicholi police was very clear in their submissions that we have complied with the orders. That when the notices were issued to us on Thursday and Friday, we complied with it and we submitted before and participated with the investigating agencies. The problem was there were certain remarks that were made by the trial court in rejecting the anticipatory bail. So we raised those contentions before the Honorable Court, stating that these were they were not required, and they were causing prejudice to the entire judicial this body. So and the decision of the case. So we were very clear in that part, and the remarks were recorded, and probably they will be expunged from the earlier trial court order.
Because High Court, I have heard that High Court also observed that it is not matter of merit of the issue, merit of the case. It is the application for the anticipatory bail. So we have to decide that his arrest is required at this point of time or not.
No, it's not. His arrest is not required at this point of time. And in the oral order in itself, the apprehension of arrest has been taken care of. So probably the arrest wouldn't take place. And if there are further notices issued to us, we will definitely go into we will submit and participate with the investigating agencies.
Going as per law, what is the next course of the legal proceeding in this matter?
It's a subject matter of trial. The trial court has to decide for deciding the matter whether there is sum and substance. We can either also go for the purpose of discharge, whether the sum and substance is there pertaining to hurting the religious sentiments. Whether the element was there or not, that we can explore. That is open to judicial interpretation.
Okay. So there is a little bit confusion regarding the word granting anticipatory bail, because one side, means intervener side, are claiming that anticipatory bail is not granted, it is simply disposal. We have to wait for the detailed order and we will see and we will update that what is the exact order of the High Court. For now, according to counsel representing Subhash Velingkar, claims that anticipatory bail has been granted. With Chetan Gavas, Mukesh Kumar for Prudent. So we have counsel representing intervener Cruz Silva, advocate Amit Palekar. Sir, what is the order of the High Court? You are saying that it is simply disposed of and there was no matter of granting anticipatory. Please simplify it.
No, it is very simple. The law on the subject is very clear. When the notice under section 35 of BNSS is issued, you have to comply with it. When the punishment is less than 7 years. In this particular case, it is 3 years. Now, in such case, whenever a notice is issued, there is no question of arrest. Now, there is a provision under which you can arrest, but there has to be a reasons recorded for writing if there is non-compliance with the notice. If there is non-compliance with the notice, there is also a requirement that you approach the JMFC and seek permission of JMFC for the reasons stated in the application as to the reason for the arrest. Now, of course, he had not complied with the notice when 3 notices were pasted on his house. But that particular procedure of going to the JMFC was not done by the police. So when the question came up on the last date of hearing that what is the reason why this has not been complied with, there was no answer which came from the police, because maybe a lapse or maybe negligence, whatever could be the reason, that did not happen. And then a statement was made by the counsel for the petitioner that that he would comply with the notice which is issued by the police, and that statement was accepted by the High Court, accepted by the state, who said that we will not arrest if he complies. He has complied. He has appeared before the court on 10th, appeared before the police on 10th and 11th, and today it was for compliance report of his whatever that, and the state has submitted that he has been interrogated for whatever reasons. They have carried out investigation. Now is the question of recording statements of the witnesses, complainants and others who have filed the complaint, and there is no need of arrest. In such circumstances, there is no question that court can grant anticipatory bail, because there is no question of arrest. And I think that being a lawyer, it is also our duty to stand by the law and concede to certain things as far as the procedure is concerned, and that is what has happened today. The court has come to a conclusion. There was no need of arrest, so there is no question of granting anticipatory bail, and hence the matter has been disposed of simply sita, but with a observation that the observations made by the learned additional district judge on the merits of the case should be expunged from the order which has been passed by the learned additional district judge. So that is what is the sum total of proceedings as far as today is concerned.
So, role of intervener is ending here?
No, certainly not. Role of intervener does not end here. The role of intervener as a complainant starts now. I'll have to produce as an intervener, Mr. Cruz Silva, and the others will have to produce evidence before the JMFC, before the police, as to what was the reason for them to file these complaints, the basis of those complaints, the evidence of how incitement was done, the statements were made to incite, and to basically comply with the ingredients of section 299 of BNS, where evidence will have to be produced and collected by the police. So actual role after intervention was only for the purpose of opposing the bail application or anticipatory bail application. That role is over. Now the role for putting or bringing the accused to justice, bringing the accused to the stage of punishment as far as the trial is concerned, the role starts now.
Thank you for talking to us. So, Advocate Palekar is saying that there is no issue of arrest, hence there is no requirement of granting anticipatory bail. But we will see in the detailed order that what exact words is used by the High Court. With Chetan Gavas, Mukesh Kumar for Prudent.
Intervention application. Now the PP submitted was called on 2 occasions and he has complied with the notices. They have further stated that investigation hasn't chalu hai, and if need be they will issue a notice, and the court has directed him to comply with 35 the notice if it is issued to him again, to comply with it and come to the police station. Now besides this, the advocate for the applicant has submitted that there are certain observations made by the district court while rejecting the anticipatory bail applications which were on merit, and he pointed out those paragraphs which were based on the merits of the case, which is the correct position of law, because the merits of the case is to be decided at the final order and final judgment, when the final judgment is to be passed. So the court has directed that those specific paragraphs which are mentioned may be expunged from that order. So the court said that by the end of today's session, the court will pass a detailed order on this, and the court will that's when we'll know which paragraphs have been expunged, because the court will have to check whether they are actually based on the merits or whether they are submissions that are made. Besides that, now Velingkar has to only comply as and when he is required and cooperate with the investigation. That's it. Besides that, there is no other order that is possible. Thank you.